so now it is on. There is a juvenile? Okay, thank you. First case then, is there anything before we start? Yes?
No, I was gonna say, we could just wait, because he's still, the cameras are gonna pick him up if we get it.
Oh, First one is Linda Francois. Oh, there she is. Okay, gotta get used to this. All right, ma'am, you are charged with battery, domestic violence. I do find probable cause. Anyone want to be heard on the bond?
Yes, Your Honor. The state is recommending a $1,000 bond with no victim contact.
Okay. All right, it's $1,000 bond, no victim contact. Do you live together? Oh, wait, main jail. It's on, but I can't get the sound. Oh, someone turned it all down. Okay, try again. No, still can't hear you. Oh, they're off, right. Okay, now, gotcha.
Good morning, Your Honor. Can you hear us?
Good morning, I can.
Thank you. Judge, I believe this is Miss Francois' apartment, so the co-arrestee who's also on the docket will be residing elsewhere. She's lived here in South Florida her whole life. She's lived in Davie for more than 5 years. She works at Whole Foods making pizzas, and her family is her mom and her sister also in the area, Judge. We're going to ask if the court would place her on pretrial release back to her apartment.
Your Honor,
Yeah?
if I may, Eric Linder on behalf of the state. I understand what Mr. Goldberg's representing, that his client has advised him that she resides there, but I am noting that both parties have the same listed address. And I'm just asking that the court really not make that determination at that point. Frankly, we'd be requesting, and I'll make the same request when we get to Mr. Minor, that the court issue no victim contact, and however the resident's situation works out, frankly, since he has a no bond hold, I would imagine she would be able to get to the residence first, but
Yeah.
as far as ordering who can stay where,
Are the altercation was between the two of them?
yes.
They're both charged?
Yes.
That's what I meant. Okay, all right, it's $1,000 bond and, no victim contact. That means you can't, call him, text him, have a friend talk to him for you. And somehow you guys are gonna have to work out who stays and who leaves, okay?
Judge, there are two cases that the main jail has requested be called out of turn.
Okay, I'm gonna I have to take a break for 1 second, so I don't know how to turn this off. This one? Yeah, but nothing happens. I didn't order pretrial. Oh. Okay, well, I don't do magistrates every day, so you gotta let me know what you're handing me to sign, okay? Okay, that's fine. Now I know. Can you, make sure that the stamp for these stamps that you put on here, they're too light, and I feel like they wouldn't, it's possible they can't read it. So if you could just put the stamps on brighter, that would be great. Okay. Don't know what this is. And I'm gonna leave them here, 'cause whoever designed this didn't do a great job. Okay. All right, did I do Karen Buster?
She's in Paul Ryan, Your Honor, and her husband is present.
All right, let's do that. Oh, you wanted me to do two others first. All right,
There's actually only one other judge. We could do Miss Buster first.
all right, thank you. All right, sir, no, ma'am, you're charged with battery domestic violence. I do find probable cause. Would you like to be heard, sir?
Yes, ma'am, I would.
Okay, could you raise your right hand? Swear and affirm that everything you'll tell me today will be the truth.
Absolutely.
All right, can you put your hand down? What's your name?
Sig Buster.
Okay, and are you the victim in this case?
Yes, ma'am.
Okay, what do you want to tell me?
I would just say, Your Honor, that we've been together 25 years. Things got a little out of hand. I would request, if you would, Your Honor, to please release her on recognizance. We don't have any trouble living together. Everybody knows you're married 25 years. Things are going to flare up once in a while. We've had a very emotional week. One of our relatives was called to us at 3:30 in the morning and told that he was dead. Now he's not. So it's been a roller coaster ride along with the holidays. Everybody knows it gets a little stressful.
Okay.
And this is a one-time incident, and I don't think this is
Okay.
necessary. I asked the police officers yesterday not to do this, and they did it anyway.
Okay. All right, State, do you have anything you want to say?
Yes, Nahum Joseph on behalf of the state. The state's recommendation for bond is $1,000, plus due to the fact there was mention of alcohol, state's requesting no alcohol, no intoxicants, and a substance abuse evaluation with any recommended follow-up treatment.
Judge, I'd ask you to release Miss Butler on her own recognizance.
All right, I'm gonna do, I'm gonna put $1,000 bond on it, okay?
Judge, I'd ask you to release her on her own recognizance. With all due respect to the husband in the case, it appears, according to the report, that he was intoxicated at the time. He said that she did nothing
I
wrong.
read the facts. I don't think it comes down to the facts, okay? It's $1,000 bond. I will say no harmful contact with the victim, but other than that, that's it. Okay? So, it's $1,000 bond, and, you know what, I'll lower it to $500. I'm gonna make it a $500 bond. And no harmful contact, meaning if there's any more altercations, you're gonna get arrested again, and then there'll most likely be no bond and new charges, okay? All right,
I'm sorry, you said you lowered to 500?
500. Okay. Next one is Jessica Finnegan. Is there any reason I have to take these out of order from the jail? I
Generally,
prefer
when the
not
jail
to.
asks, Judge, it's either for medical reasons or security reasons, and
Okay.
there's one of them.
All right, so what are they before I get to Jessica
Okay.
Finnegan? Who are they?
It's just Mr. Alvarez. He's on page 11 of the court's docket. Isaac Alvarez.
Now I gotta look for it, so give me a few minutes.
I'm afraid so, Judge, yes.
And it's the main jail?
Yes, he's at the main jail.
Isaac Alvarez. All right. Charged with resisting without violence. I do find probable cause. Anyone want to be heard on bond? No? Okay. $100 bond.
Adam, we can't hear you.
Oh.
Can you hear me?
Oh, there it is. Okay, I'm sorry.
That's okay. Nothing from the defense. Thank you, Your Honor.
Okay.
All right. You're done. Go back on that one.
What's the next one?
That was the only one, Judge.
Oh, okay.
Your Honor,
Yeah.
just letting you know we have the Spanish interpreter present also.
Oh, yes,
Okay.
our Spanish interpreter is present.
Okay, does that mean I have to go through all of them? Take them out of order?
I mean, I guess the one or two ways
Well,
that are
okay.
easiest is.
Probably aren't there many other courtrooms right now that are you being called anywhere else right now for? Okay, so let me know if you start getting called to be in other courtrooms, okay? All right, Jessica Finnegan. Anybody? Here she is.
In jail. We're here, Judge.
All right, you're charged with battery, domestic violence. I find probable cause. Anybody want to be heard on bond?
Your Honor, the state's recommendation would be $1,000 bond with no victim contact.
Judge, Ms. Finnegan's advising this is her first ever arrest. If that's the case, we'd ask that she be released on her own recognizance.
Okay. Does, can you review that? Okay. Where does she live? Does she live with the victim?
Judge, she does not live with the alleged victim. She lives in Pompano. She's lived there for the last 4 years. And she's lived in South Florida all of her life. She's working, doing banquet works for a hotel.
All right, I'm gonna release her ROR. No victim contact, you understand? That means you can't call him, you can't text him. Okay, the charges are still pending, okay?
Thank you, Your Honor.
Thank you. Next is Gina Seegers.
Paul Ryan.
Seegers, you're charged with aggravated stalking after an injunction for protection against, repeat dating.
It's
Basically, the charge is aggravated stalking after a injunction was issued, correct? I do find probable cause. Anybody want to be heard on bond?
Yes, Your Honor. As the court can see from the paperwork in front of you, this is actually count 3.
Oh,
Ms. Seegers bonded on count 1, and she was placed on pretrial release on count 2.
what was count 1 and 2?
I would ask the court to.
What was count 1 and 2?
Um,
Count 2 was a violation of injunction, I recall that case, she was placed on.
79,
Okay.
7090. What's your number?
why this wasn't all combined in front of Judge Malika at one time, I don't know. The allegation here is that Ms. Seegers sent a correspondence to the victim through the mail.
There's a lot of
There
Details
have
here.
been.
I'm not in a position to I don't believe that I'm gonna do the ROR. I know it's an ad charge. You wanna be heard?
I would, Your Honor.
Okay.
Your Honor, I'm going to be requesting a $10,000 bond pretrial release with a GPS monitor level 1. My concern is if Ms. Seegers, she was in custody for violating a court's order having contact with this victim. If she's brazen enough to have contact and violate a court order while in custody, I have no confidence that she will not continue to violate this order when she's not confined in the jail.
I agree. $10,000 bond. What was it? Electronic
GPS level 1, Your Honor, which would be home lockdown.
level 1. Okay.
And
no
obviously,
victim.
even though she's been ordered previously, I would ask an additional order of no victim contact on this separate case.
Okay, do you understand that, sir? It's not, it's just an ad charge, it's not a separate case. I mean, ma'am, do you understand no victim contact? Do you understand what that means?
Yes, ma'am.
What does that mean to you?
It means I'm not allowed to phone, text, email, or go anywhere near my boyfriend.
Okay? And there's also a $10,000 bond, and if you were to make the bond, there's going to be a GPS, and they'll explain all
Yes,
that
ma'am.
to you.
And Your Honor, just so Ms. Seegers understand, this actually is going to be a third separate case.
Oh, it is?
It's going to be filed, it's going to be,
Oh, because it happened while it was in the
yes,
in
and it'll have a
custody.
felony case number.
Okay.
Excuse me, ma'am?
And this one will be a felony, correct? Okay. Next one is
Yeah,
Raven.
excuse me, ma'am?
Yes.
Excuse me, ma'am? I live alone. My entire family is in South Africa, and I need to be able to work. I have a job on a mega yacht. And without being able to work, I will be unable to pay my rent, pay my car insurance, and pay my car payments. So there won't be any point to really be, living in my apartment if I cannot pay one bill. I please
Okay.
ask, ma'am, that I be able to work. Please, ma'am.
This case will go to your regular judge. If you need an attorney, you can hire one. If
I have
you-
one.
Well, then get your attorney to argue that in front of the judge. But at this point, I'm just the magistrate judge today, and that's my ruling. And I'm going on to the next case. Raven Thurston. Anybody?
That's North Broward?
Raven North Broward. Okay.
Yes, ma'am. She was sent to court this morning, room number 9165.
I suspect that's for the family court issues. It mentioned CPIS was involved, so
Okay. All right. So, Janice Worrell.
Main jail, Your Honor.
Hey, you're charged with aggravated deadly weapon, domestic violence. I find probable cause. Anybody want to be heard on bond?
one moment, Your Honor, while I'm pulling the priors, if Mr. Goldberg wants to proceed, though, that's fine.
I'm sorry, I can't hear you.
Sorry. Your Honor, I'm just pulling her history. If Mr. Goldberg wants to proceed first, I'm fine with that.
Judge, the home belongs to Miss Worrell, so the alleged victim does not reside there. She's lived in South Florida for the last 60 years. She just started a job doing lawn service, so she's making $15 an hour there. I'm going to ask if the court will place her on pretrial release to the home which she resides in.
And again, Your Honor, same argument. The report lists the same address for both of them. It says they've been living together for the past 30 years. I'm asking that the court issue a no contact order and frankly not take any position about who can reside where at this point. I don't think that's really for this court to make that determination
Are you
today.
asking, what was the amount you asked for the bond?
For bond, and I can tell you, Judge, she has drug priors, no prior domestic violence. Considering this involved a knife and there was a threat to kill, I would be requesting a $5,000 bond, no victim contact.
Judge, and just to respond, I mean, she's 60 years old. She just started working. She wouldn't be able to afford the $5,000 bond. So we'd ask for pretrial.
Okay. I'm gonna make it $1,000 bond and no victim contact. So somehow the two of you are gonna have to decide who's gonna be staying at that residence, but you cannot contact each other. Okay? So basically, you can't contact him. Okay. Michelle Wilson.
North Broward.
Same right there. There you go.
This is a misdemeanor, good morning, this is a misdemeanor capias.
This is out of Judge Lerner Wren's Mental Health Division, Your Honor.
Okay, so I am going to, I find probable cause, and I'm not gonna set a bond. I mean, what is the bond on it now?
Judge Lorenz said
There is
we
no
have
bond.
Yeah.
Right, no bond, okay.
All
All
right.
right, good luck.
So,
Next
so
one-
I won't be getting out of jail? Is that what it is?
Eventually, but you're gonna go to the court, the
I'm
judge.
confused now.
Okay, the judge who had this case, who you're assigned to, she issued a no bond hold, right?
Yes, and Your Honor, Judge Lernerent's judicial assistant is aware that she's in custody, so in the meantime, whatever measures are needed for her to receive an evaluation, I'm sure will be taken.
Okay, I don't know when she's having
That's a
court.
serious charge. Why?
Okay, I don't know when the judge is having court again. I don't know if she's in next week or the rest of this week. But at that time, you'll get a court date, okay? All right, thank you. Next one
I
is,
get to go to magistrate, right? Magistrate, and
this
then
is
talk about
magistrate.
it.
You can't talk about it here. You'll go to the regular court, Judge Lerner Wren, and you can talk about it there, okay?
I just hope I get out of jail soon.
Okay. Katiana Salant.
Main jail?
All right, charged with DUI, 2 counts, and failure to use due care. I do find probable cause. Bond is set at 500 and 1,000 on count 2. Does anybody want to be heard on that?
Judge, she's wondering if her bond has already been posted.
Oh, I don't know. I don't know. Okay.
Just confinement status?
They're checking.
Not yet.
Not yet.
Not yet? Okay. Nothing to add from the defense.
Okay. Orlando Valcourt. Okay.
She had north? Oh, never mind.
Oh, there she is.
Based-
Okay, you're charged with disorderly
Judge,
conduct.
did you call Miss Valcourt?
Yes,
She's up in North Broward, Your Honor.
thank you. All right. Orlando Valcourt. Maybe she bonded. Tammy Johnson.
Your Honor, the deputy from North is right there.
Tammy Johnson's medical reset.
What about Ms. Valcourt?
Ms. Valcourt hasn't come down yet. They're calling for it now.
Yes.
All right, I'll recall that.
Your Honor, can we put Ms. Valcourt on recall, please?
Yep.
Thank you. Deputy, if you could just let us know when Ms. Valcourt's there, please.
Tyeri
Thank
Green.
you.
Okay, Tyeri Green.
Main jail, Your Honor.
All right. There's Capias. I guess it's out of, yeah, Broward, and it's no bond. But you do have a hearing set for tomorrow at 8:30. Okay?
Thank you, Your Honor.
Brittany Strobridge.
Bond
Judge, she
posted.
bonded?
Okay. Okay, Manalo Jose Salgado Alduven.
Main jail, Your Honor.
All right, you're charged with battery domestic violence. I do find probable cause. Anybody want to be heard on bond?
Yes, Your Honor. State's requesting $2,000 bond with no victim contact. Reason for the $2,000 bond is due to the fact that there was a child present during this the altercation.
Nothing to add from the defense, Your Honor.
Okay. I'm gonna set the bond at $2,000. Sir, no victim contact. If you do live in the same place, you will not be able to go back there. And you cannot contact the victim through phone, text, social media, or other people. So you can't tell other people to send a message to her. Okay, so no victim contact. All right, Giovanni Smith.
Main Joe?
All right, sir, you're charged with battery, domestic violence. I do find probable cause. State,
State's requesting $1,000 bond with no victim contact.
okay?
Judge, he's advised me this is his first ever arrest. If that's the case, again, we'd ask that he be released on his own recognizance.
All right, so $1,000 bond, no victim contact. That means no text, no phone phone calls, emails, or asking a friend to contact them for you. And you can't go back to, if you're living in the same place, you can't go back there. All right, understand that, sir?
Yes, ma'am.
Okay. Acosta, Victor Luis Acosta.
I'm sorry, sir. You finished?
There you go.
Sir, charged with domestic violence, battery. I do find probable cause. State,
The state would be requesting, based on the facts, a $2,000 bond with no victim contact.
defense.
Judge, he's lived here for the last 13 years. He lives with his girlfriend in Davie. He works on boats, making parts and laminating. He makes $12 an hour. We would just ask for the lowest reasonable bond.
All right, $1,000 bond. No victim contact. You understand, sir? No calls, no texts.
Yeah.
No one telling someone, can't tell someone else to talk for you.
Yeah.
Okay. Okay, you got it.
Good luck. David?
Antonio St. Claver Davis. So you're charged with domestic violence, battery, domestic violence, and I do find probable cause. State,
Your Honor, based on the facts, state's requesting a $2,000 bond with no victim contact.
Judge, he's telling me this is the first time he's ever been arrested. Again, if that's the case, we'd ask that he be released on his own recognizance.
all right, it's gonna be $1,000 bond, no victim contact. No phone calls, no texts, no one else reaching out to her for you, okay?
You're done?
Malik Devin Butler.
North Broward.
Jaleel?
All right, sir, you're charged with domestic violence, battery, as well as a capias from traffic court. I believe that was at North Satellite? I'm not sure. Okay, I do find probable cause. State,
Your Honor, the state would be requesting a $1,000 bond, no victim contact, and a mental health evaluation with any recommended follow-up treatment.
defense.
Judge, he's never been arrested before. He lives here all of his life. He's been living at the same location for the last 6 months, but he does have a place to stay with his aunt where he would not have contact with the alleged victim in the case. He's working currently at Subway. Obviously, he's very concerned about losing his job. He is a high school graduate, graduated high school in 2016. He's a registered voter. Based on the fact that he has no prior record and strong ties to the community, I'd ask the court to consider releasing him without a monetary bond being necessary.
Okay, so is that pretrial release or just ROR?
Well, I'd ask for an ROR, but if you're inclined to put him on pretrial, that would be an acceptable alternative.
Okay, we put him on pretrial.
Your Honor, I did hear the state ask for a mental health evaluation.
Yes.
Are you gonna keep the bond in place or no bond necessary?
There is no bond, other than the 250 KPS for traffic offense.
The battery, we're gonna put RORs for pretrial services, okay?
Right.
And then you're gonna put the KPS on pretrial as well? I just prepare separate.
Yes.
Okay, thank you.
Okay. Okay, and then.
Thank you, Judge.
No victim contact, okay?
Yes, ma'am.
All right, sir.
Sorry, Your
So,
Honor, are you still doing the mental health evaluation?
yes.
Okay.
Sir, you're going to be released through pretrial services. They'll contact you and let you know. You cannot contact the victim. No text, no phone messages, no social media, nothing. And then there's also going to be a mental health evaluation. Okay?
Yes, ma'am.
All right. Good luck to you, sir. Jazuel Delion.
Main jail, Your Honor, and we'll need the Spanish interpreter.
Oh, is he here? We lost him. Okay, recall.
Okay, you can have a seat.
John Gonzalez. All right, sir, you're charged with battery, domestic violence, and a parole violation. I do find probable cause.
Your Honor, state would be requesting a $1,500 bond, no victim contact, considering he has a no bond parole hold that is out of another state.
Okay. I'm gonna do that. It's gonna be a $1,500 bond on count one, but there's a no bond hold, obviously, on the parole violation, okay? And no victim contact. All right, Ralph Sidney. Sir, you're charged with domestic violence, strangulation, and aggravated battery. I do find probable cause, state bond.
Sorry. Your Honor, the state would be, I see no history, but I would be requesting a $10,000 bond on count one, $1,000 bond on count two, no victim contact. I'm concerned for the victim's safety based on the lengths that Mr. Sidney went to attack the victim, breaking through a bathroom door after she sought protection.
Judge, Mr. Sidney has advised me he does have somewhere else that he can go stay. He's lived here in South Florida for the last 11 years. His father is here. His sister is here. He's worked as a mechanic, held the same job for the last 11 years. He makes about $900 a week, he told me. So he said the most between the two that he could afford would be $500. And so we'd ask the court to set the bond in that amount.
All right, I'm gonna send count one at 5,000, count two at 1,000. No victim contact. Okay? You can't call her, you can't text her, you can't have a friend call her or text her. You understand that, sir? Okay. Hanley J. Freeman. Okay, sir. You're charged with battery, domestic violence, as well as a probation violation. You have a hearing tomorrow at 8:30 on the violation of probation. I do find probable cause.
Your Honor, state would be seeking a $5,000 bond, noting the injuries suffered by the victim. And Your Honor, I would also note the case, this victim is the same victim as the case Mr. Freeman is on probation for.
Judge, first thing I'd ask for is a photo order. Mr. Freeman sustained some injuries.
All right, what was the bond you were asking for?
5,000.
Count one is going to be,
Judge, if I could be heard on the bond?
sure, go ahead.
Sure, the first thing that I would ask for is a photo order for Mr. Freeman. He
You
sustained some
asked
injuries.
for that already, and that's granted.
Thank you, Your Honor. He does not live with the alleged victim. He's lived in South Florida his whole life. He lives with his mom here in Fort Lauderdale. He just started a construction job, and though he's been working, he hasn't gotten paid yet. He's going to be held no bond no matter what, and he's unable to afford the $5,000
Well, no
bond.
bond on count 2, but.
Correct. Yeah. So we would ask for a bond less than $5,000 for count 1.
All right. Count 1 is a $5,000 bond. Count 2 is no bond, and there's no victim contact. You understand that, sir? Can't contact the victim.
Yes, ma'am.
Okay. Next case, John Kennedy. Sir, you're charged with ag assault, deadly weapon, domestic violence, 3 counts. I do find probable cause. State.
Your Honor, I'm going to be requesting for a $3,500 bond on each count, based on the allegations that he threatened his 3 children with a machete. I do see he was arrested in 2010 for domestic violence battery against a different alleged victim. That charge was dropped. Nothing further.
Defense?
Judge, my understanding is that all 3 are up in New York and not residing with him. They're not going to be back here until after the new year. Mr. Kennedy is going to relocate to a home down in Miami. He's lived here in South Florida since 1993. He works as a general contractor. And so we're asking for a bond of $1,000.
All right. I'm gonna make the bond counts 1. Count 1 is 5,000. Count 2 is 1,000. And count 3 is 1,000. No victim contact. Any of the victims. Can't call them. You can't have somebody talk to them for you. Can't text. Nothing on social media. Okay?
Okay, Your Honor.
Oscar Minor. All right, this is a battery domestic violence. I do find probable cause. There's also probation violation. And that is set for hearing tomorrow at 8:30.
Your Honor, excuse me. State would be requesting a $2,000 bond. There is concern that he's on probation for a domestic violence offense, even though it is against a different alleged victim.
Okay. And I do find probable cause, in case I forgot to say that.
Judge, you did set a $1,000 bond for the co-arrestee.
She wasn't on probation for domestic violence.
Okay, I'm gonna set the bond at $5,000.
Judge, I believe the state recommended 2,000, and we were not gonna add anything to that because he said that he could afford it. He could go stay with his brother. Obviously, this is the co-arrestee from the other person. He's lived here in South Florida his whole life. He's working landscaping. He's not able to afford a $5,000 bond, so we'd ask for the state's recommendation as well, which I think was $2,000.
I'll be the first to admit I'm not right 100% of the time. If Your Honor thinks that the bond I was asking for is too low, then the court should set the bond Your Honor believes
All right.
appropriate.
The bond is $5,000, no victim contact, and no bond on count 2. Jeffrey Stanley. All right, you're charged with aggravated battery on a pregnant person, domestic violence. I missed this one. 1 second. All right, I do find probable cause.
Your Honor, the state is going to be requesting a $15,000 bond pretrial release of the GPS monitor. First, I am concerned about the level of violence alleged in this case. Additionally, the court should be aware Mr. Stanley is on federal probation until August 15th of 2021 for a felon in possession of a firearm.
All right, defense?
Judge, we were going to ask for a $5,000 bond. He does not live with the alleged victim. He lives with his mom and her boyfriend and their kids. He's lived here in South Florida his whole life. He also has a sister here in Broward. He's supposed to be working today. He works construction. And if it's $15,000 again, he makes an hourly wage of $15 an hour, so he's unable to afford $15,000. So we'd ask for $5,000.
All right. I'm setting the bond at $10,000 and no victim contact.
Your Honor,
Yes.
as far as the GPS, I believe that's reasonable considering that he is on supervision from the federal government, and I suspect they're going to be seeking a warrant, but until then, I think it's reasonable for law enforcement to be aware of his.
Okay, and a
threat.
GPS monitor if you, when you make the bond. Okay, and no contact with the victim. No phone calls, no text messages, no social media, nothing. Next case is David Nicholas.
Good morning.
One second. Okay. You're charged, sir, you're charged with aggravated assault, deadly weapon, domestic violence. You also have a probation violation. That hearing is set for tomorrow at 8:30. I do find probable cause. State, do you want to be heard?
I'm requesting a $7,500 bond, noting he's on probation. But I'd also note that there were threats to kill not just the victim, but her mother and both children.
Judge, we'd be asking for a $2,000 bond. He can't afford the $7,500. He does not live with the alleged victim. He's lived here in South Florida his whole life. He lives with his mom and his sister and his brother. He works as a supervisor at Popeyes. He's been working there for about 2 weeks.
All right, I'm gonna set the bond at $5,000. No victim contact. That means you can't call her, you can't text, you can't get someone to talk to her for you. You understand that, sir? And you have a court hearing tomorrow at 8:30.
Your Honor, North Broward advises that they have Miss Valcourt.
Okay.
See? Ready.
Okay. Ms. Valcourt. Orlando Valcourt.
Ma'am, she's
Difficult.
using the restroom right now.
Okay, I'm gonna recall.
Our Spanish interpreter is present, Judge.
Jazuel De Leon,
Really?
Spanish interpreter
That
case.
doesn't sound like someone that's using the bathroom.
Okay.
Yeah, you can have a seat. Hello? You can have a seat for right now. I've got him, Judge.
All right. Sir, you're charged with aggravated assault with a deadly weapon, domestic violence.
Usted está acusado de agresión agravada con arma mortal en un contexto de violencia doméstica.
And count two, state, what is that?
¿Cuál es la fiscalía que dice?
It's the depriving means of communication with 911.
Okay.
Privarle a la víctima de los medios para comunicarse con el 911.
All right, I do find probable cause.
Considero que existen indicios probables.
Your Honor, I see no history.
Su señoría, no veo antecedentes,
That being said, I'm requesting a $15,000 bond on count one,
pero aún así voy a solicitar una fianza de $15,000 para el primer cargo,
a $2,500 bond on count two.
$2,500 para el segundo cargo.
Your Honor's familiar with the facts, the
Su señoría está
allegations,
familiarizada con las acusaciones, lo que se alega,
but I have safety concerns based on the alleged use of a firearm.
pero tengo preocupaciones con respecto a la seguridad dado el supuesto uso de un arma de fuego,
While verbally threatening to kill the victim.
mientras se utilizaban amenazas verbales de matar a la víctima.
Obviously, I'd be requesting no victim contact.
Obviamente solicitaría que no hubiera contacto con la víctima.
And while it is a standard condition of a domestic violence no contact order,
Y si bien es una condición de rigor de este tipo de órdenes de no tener contacto en una situación de violencia doméstica,
I would ask if Your Honor would directly instruct Mr. De Leon not to be in possession of any firearms or weapons.
le solicitaría a su señoría que instruya directamente al señor De León en el sentido de que no puede poseer armas de fuego.
Nothing further, Judge.
Nada más, señora juez.
Thank
Judge,
you.
I'm sorry.
I just said thank you. You may proceed.
Judge, we were going to be requesting a $2,000 bond in total between the two.
Señora juez, íbamos a solicitar una fianza total entre los dos cargos de $2,000.
I understand that he'd be able to go live with his boss
Tengo entendido que él tiene la posibilidad de ir a vivir con su jefe
out in Coral Springs.
en Coral Springs.
He works as a barber, making $350 a week,
El señor trabaja como barbero, ganando $350 por semana.
and he's lived here in South Florida for the last 4 years.
Y ha vivido acá en el sur de Florida durante los últimos 4 años.
Nothing further.
Nada más.
All right, I am going to make bond 5,000 on count one
Bien, la fianza va a ser de $5,000 para el primer cargo
and 5,000 on count two.
y $5,000 para el segundo.
There's no victim contact.
Se le prohíbe tener contacto con la víctima.
Means you can't call the victim, text the victim,
Eso significa que usted no puede llamar a la víctima, no le puede enviar mensajes de texto,
or have someone else contact them for you.
ni tampoco puede ordenarle a otra persona que la contacte en representación suya.
Also, you cannot possess firearms
No puede tampoco poseer armas de fuego
or any weapons.
ni arma alguna.
Do you understand, sir?
¿Entiende, señor?
Yes.
Okay. All right. Good luck to you.
Bien, buena suerte.
Any other cases that you know of that need a court interpreter?
¿Alguien más necesita intérprete al español?
Not in Maine, Your Honor.
Okay. All right. Norberto Nieves. All right, sir, you're charged with domestic violence, battery. There's also a probation violation, which you have a hearing set for tomorrow at 8:30. I do find probable cause. State.
Your Honor, I'm going to be requesting a $3,500 bond, no victim contact. This is based on the level of violence, the injury suffered by the alleged victim, the allegation that the victim's child was present when this occurred, also noting that he is on probation for DUI, serious bodily injury.
Judge, we were going to ask for an amount less than that. He lives by himself, so he does not live with the alleged victim. He's not working right now. He's getting ready to start a new job on Monday. He lived here in South Florida for the last 6 years, and his family's going to try to help him with bond, understanding that there's a no bond hold on count two. So we were asked for a bond less than what the state has just asked for.
And I would just note, the address on both the booking sheet and the probable cause affidavit show the same address as the victim's.
Okay. What did you ask for again?
3,500.
Okay. On count one, I'm gonna make that a $5,000 bond and no victim contact. You have a hearing tomorrow in front of the judge that you're on probation with. That means that you can't call or text or have anyone do that for you. No contact with the victim. And that's it. Danielle Jeffs.
North Broward.
Good morning, Your Honor. Devika Carr on his behalf.
Hi.
Hi. I cover for Steve Shade. I'm asking to be appointed on behalf of the public defender for the city municipal ordinance.
Okay,
Thank you.
I'll do that.
Thank you.
And this is Capias. There's a $100 bond in count one $250 bond on count 2, and a hearing set December 30th at 9.
That's correct, Your Honor. I did speak to Mr. Jeffs. He cannot afford his bonds as they're set. The first case, he failed to appear at his arraignment November 7th. The second, he failed to appear at his arraignment November 25th. Mr. Jeffs was originally, for one of these cases, assigned to community court at City Hall on Wednesdays. However, he was transferred back for non-participation. However, I would be asking if Your Honor would be inclined to allow him to resolve these two cases today to a credit time served offer.
No, I'm gonna have he already has a court date, I'll let them handle it.
And is Your Honor willing to reduce the bonds in any way?
No.
Okay. I'm sorry, Mr. Jeff, you'll have to wait until December 30th to see the division judge, okay?
All right.
All right.
See you then. Thank you, Your Honor. May I approach with my orders? Do you want me to wait to hold them all at once, or as I finish a case? The orders to be signed?
Oh, you can do it all at once. Donald Gordon?
Main jail, Your Honor.
Okay, this is a capious.
Judge, Mr. Gordon was wondering what date the capias was issued.
November 12th.
November 12th. It's a petty theft. Do you want to resolve it today?
He does.
Okay. State your recommendation.
Your Honor, I'm checking to see what the documented offer from the state is. Your Honor, there's no offer from the state, and I'd ask that the court not entertain an offer. There is restitution in this case.
All right, so I'm gonna keep the bond at $50, and it should be going to your regular division as soon as possible.
Judge, he would just ask for an order allowing him access to his phone so he can get access to his contacts and call someone to post the bond.
Okay, no problem. I'll allow that. All right, Charles Coleman.
He's coming up, Your Honor. It's an MO.
Yes, Your Honor. Davika Carr on his behalf asking to be appointed. This is also a municipal ordinance.
Okay. All right, you're charged with 2 municipal ordinance violations. The bond is $100 on count 2. There's no bond on count 1. I'm not gonna resolve it today. I'm gonna
Your Honor,
let
he
it
does
go
not
to
have a
the division.
future court date, so if he cannot afford his bond, he'll essentially be held on a $100 bond, which is willing
Well,
to
I
ROR
think they're
him.
supposed to give him a court date pretty quickly. So,
Right, but these are just MO cases Your Honor's not inclined to allow him to resolve. Panhandling and resisting without violence.
I mean, I'd have to know what his priors are.
I can, if you want, Your Honor, I can
Okay, that'd
advise
be
this in front of
great.
the court.
Thank you, State.
I just need 1 moment to.
John Richards?
Your Honor, as far as Broward, he was picked up in November for a capias on another solicitation. He received time served on that. Other than that, he has hits out of multiple states,
Okay.
but it doesn't appear to be anything. I don't see anything of violence.
So you want to resolve it today? It's going to be adjudication on both counts and court costs. Okay? And yeah, that's
Next
it.
question.
Did you understand what the court?
Yes, I do want to resolve.
Okay. Adjudication and court costs.
Okay, have a good day, Charles. Thank you, Your Honor.
John Richards?
It's us right here. Oh, no, I can't afford it. That's okay.
All right, so you're charged with obstruction by a disguised person operating without a valid license, and another misdemeanor capias. You have a hearing set on the 30th at 9. Your bond is set, I do find probable cause, your bond is set as $100 on count 1 and $500 on count 3.
Judge, he'd like to resolve all these matters before the court today, if possible.
Your Honor, and the state has no objection. The documented offer from the state on charge 3, the capias, would be a withholding court cost. On counts 1 and 2, they would both be adjudication, time served, and court costs.
Do you understand that, sir?
He'd like to accept the state's offer on both.
All right, so count 1 is an adjudication court cost. You can resolve it on the 30th if you want. It's up to you.
Judge, he'd like to handle everything today, if possible.
Okay. Adjudication court cost, count 1. Adjudication count 2. And what was on the misdemeanor capias was, what was that for?
I think it was a withhold court cost.
Okay, withhold court costs. Although, again, court costs are only per case, not per count.
Good luck.
Your Honor, North Broward has Miss Valcourt back. They would like her case to be called, if that's possible.
Okay.
This is the rules of procedure. This is everything.
She's approaching.
For every case, technically speaking, if you fail to appear, the value of the monetary, whichever is greater.
This is the mystery case. All right, I'm gonna move on to the main jail. Edward Christie.
Main jail, we're here. Give me 1 second.
All right, sir. Zaccapius, misdemeanor capias. The bond is $1,500.
Judge, same thing. Mr. Christie just wants to know when the capias was issued.
State.
It would appear Judge Hurley issued the capias on December 4th.
September the 4th?
Yes. No.
December.
December the 4th, excuse me. Judge, he too would like to resolve this matter today, if possible.
We'll need 1 moment, Your Honor. Mr. Christie's come through our division many times.
Okay, I'm not gonna resolve it today, so that's it. All right, let's go back to, the bond is $1,500 on Mr. Edwards Christie's case. All right. Ms. Valcourt, you're charged with disorderly conduct, obstruction by disguised person. I do find probable cause, states you want to be heard on bond.
Your Honor, I'm just checking one.
Why you say, what do you mean you found probable cause?
Okay, that's the basic.
Because the lady told me the only reason why she arrested me.
Wait. You might not want to talk about your case, because today isn't the day that I'm going to resolve your case. So, the least you say on the record about the case right now, the better it is for you. Okay, I don't know if.
Your Honor.
Have you ever had a mental health evaluation?
Yes, she has, Judge. In fact, we are going to be requesting that this case be transferred to Judge Lerner Wren.
State
Okay.
agrees.
No,
All right.
sir.
I will notify Judge Lerner Wren, judicial assistant.
Okay, the bond is gonna be set at, $100 on count 1 and $100 on count 2. Okay?
Ma'am, they just told me I only had 1 charge.
There's
And she
two-
said it was only gonna be $100. Right now, I don't have no money.
I understand. And they're gonna move this case to, Judge Lerner Wren's division, and, if you can make the bond, great. If
I
not,
don't have nobody to call, and I left my money in the car. I own my card.
okay. All right. I don't know if you have an attorney or if there's anyone there who can assist you, but, talk to them and maybe they can help you. All
We
right?
will be signing her up with the Public
Can
Defender's
you
Office,
call
Judge.
one of my lawyers that's on a previous case of mine?
They're gonna contact you. That's what I just heard. Okay? The Public
Are you
Defender's
good?
Office is going to contact you. Okay?
Steady.
All right. Thank you.
Thanks.
Thomas Pasaronic.
Main jail, Your Honor. Yes, ma'am.
Sir, you're charged with petty theft. I do find probable cause.
Judge, he'd like to resolve this matter today if possible.
The offer would be adjudication 3 days in county jail, Your Honor. Mr. Pasarinic just appeared before Judge Murphy yesterday on a disorderly intoxication and trespass, and according to the report, got picked up for this theft about 4 hours after his release.
Does he have prior petty theft?
Judge, he'd like to.
I don't have any priors of it.
Your Honor, I'd have to check. The adjudication, and for record purposes, the adjudication would be because of the recent arrest before it, but I'll check to see if there's any. Let's see. Your Honor, I can tell you, while I see previous arrest for theft in the state of California, I don't see a disposition. He is a convicted felon. I'm showing he's been sentenced to state prison out of the state of California.
Okay. Defense?
Judge, he would like to accept the state's offer.
Okay, so it's an adjudication, court costs, 3 days Broward County Jail.
With credit for the time.
And obviously,
No credit. No credit for time served. I mean, today's the first day he's in, so it's part of the 3. So there, you get a credit for 1.
Your Honor.
You get credit for today.
Okay, yeah.
Only other thing I'd request is an order of no return to this CVS on Federal Highway in Fort
All right,
Lauderdale.
and no return to the CVS on Federal Highway. Okay? Jacob Sanders. All right, you're charged with battery, causing bodily harm. I do find probable cause.
Your
Does he
Honor,
have priors?
I'll check, but this frankly is another case that I think should be transferred to Judge Leonard Wren.
I
Okay.
My
agree.
understanding is if it's not a domestic, she will take it.
Okay. All right.
Why transferring the judge? Why is the judge being transferred?
Okay, I only do the magistrates. I'm just here this morning to tell you what you're charged with and what your bond is. Then you go to a division that handles the case, okay?
May I ask?
Yeah.
May I ask, is it a felony or a misdemeanor?
It is a misdemeanor, sir.
Okay.
All right? And we're sending it to the mental health division. So the bond is $1,000, and we're going to transfer to the mental health division.
And Your Honor, just in an abundance of caution, I'd ask for no victim contact, please.
Do you know the victim in this case? Sir?
No,
Yeah, I'm not gonna do that. Okay,
I don't know.
Dion Green. Dion Green.
Main jail, Your Honor.
Sir, you're charged with DUI. Second offense.
I just didn't know if you wanted.
I do find probable cause. State, do you want to be heard?
One moment, Judge.
I get to hear myself twice.
I know. I have nothing to add at this time, Your Honor.
Judge, the only thing that we would be asking the court for is a phone order so he can call someone to post his bond.
I'll allow that, and it's $1,000 on each count.
Thank you, Judge.
Okay.
All right. Good luck. Michael Blackwell?
Michael Blackwell. Sir, you're charged with exposing sexual organs in public and a municipal city ordinance. I do find probable cause. Counselor, do you want to be heard?
Yes, Your Honor, I'm asking to be appointed only as to count 2. He asked to resolve, but I'm not certain if Your Honor's inclined. I haven't spoken to him as to count 1.
All right, Alex, point you to count 2.
Thank you.
And then,
Judge,
yeah, go ahead.
I'm sorry, he's gonna post the bond on count one, which is the MM that the public defender would be
All right.
involved with.
No, the MM is, oh, right, so that's $100.
Only thing I'd request, Your Honor, is an order of no return to 1735 East Young Circle in Hollywood.
Understand, you can't return to that area?
Yes, ma'am.
All right. Michael Pabon,
Okay.
Judge, he's coming up, but he also wants to resolve this KPS.
I'm looking at it right now.
Here he is.
all right, it's KPS petty theft.
Documented offer is withhold court cost, no return to Walmart at 2551 East Hallandale Beach Boulevard in Hallandale.
Judge, he'd like to accept that offer.
Okay, sir. Can you raise your right hand? Swear or affirm that everything you'll tell me today will be the truth.
Yes, ma'am.
All right, put your hand down. Are you pleading guilty or no contest?
No contest?
Anyone force you or make a promise to you to take this plea?
No.
Are you under the influence of alcohol, drugs, or medication?
No, ma'am.
Understand if you're not a U.S. citizen, taking this plea may result in deportation. Yes?
Yes, ma'am.
Okay. All right, you understand you're pleading to a petty theft. If you get, I'm not sure of the exact numbers, but they add up. I think if you get 3, the third one is a felony. I don't know if I'm right with that. I can't
That is
remember.
correct, Judge.
It
Okay.
could be.
So I just want you to be aware of that, okay? All right, so I'm going to find your plea is made knowing and voluntary. There is a factual basis. It's a withhold court costs and no return to that location. You understand, sir?
Yes, ma'am.
Okay.
Look at that way. Branham?
90 days to pay the court costs. Christopher Branham. Okay, this is a Capias traffic. There's a hearing set, but if you want to resolve it,
Your Honor, the only thing.
you can't resolve it?
Mr. Branham needs to be advised, if he chooses to plead this case out under state law, he is required to be sentenced to a mandatory, minimum of a mandatory 10 days in county jail, based on prior DWLSs. This alleged incident occurred, according to the filed information, Your Honor, on October 14th of this year. The new law went into effect, I believe, October 1st of this year.
Okay. You understand that, sir?
Judge, the first question that he had is, he's wondering if his bond has been posted.
Not yet.
Judge, he's advising that he did not receive the notice of the court date that the capias was issued. He lives in Dania, and so because of, if the notice was returned, and I don't have the information that we have in the court, he'd ask that he be released on this so that way he can come back into court.
Can I explain it to her?
It looks like notice was given to his public defender in open court. All he had to do was contact his attorney.
Can I explain to her?
Judge, again, he's just saying, I guess this was a downfiled case, and he's saying he did not receive notice of the misdemeanor of the new case.
Okay. All right. Well, there's a hearing set Monday at 9. I am going to keep the bond at $500 so he can talk to his attorney and work that out then.
Sure. Judge, we would just ask for a phone order for him.
Okay, I'll allow that. Milton
Thank you, Your
Cabrera?
Honor.
And Your Honor, if I could be heard on this case before the court makes a finding, please?
Sure.
Thank you.
Go ahead. Oh,
I'm just
not
waiting for
there
him to
yet.
get up there.
I didn't see that.
So you gotta catch these.
Present.
Your Honor, he was booked for aggravated assault on a law enforcement officer, but I direct the court's attention to the probable cause affidavit. The officer arrested him for assault on a law enforcement officer.
I'm sorry.
The
For
officer
assault?
charged him with assault on a law enforcement officer, a misdemeanor. The standard bond, I believe, is $100 for that.
Okay, but it got, somehow it was,
Somehow it got booked as aggravated assault.
okay, it was just assault. All right. Okay. So you're charged with assault on a police officer, disorderly conduct, and resisting without violence. I do find probable cause. Defense.
Judge, if the standard bond on count one is $100, we've got nothing to add.
And I show no local history, Judge, so I'm fine with that.
All right. $100 on count one, and no. I guess what there's no bond set for.
Yeah, the only thing I would ask, Your Honor, it doesn't appear he resides in this neighborhood. I would just ask that no return to this location. I won't go into the details, but based on some of the allegations of what was going on.
All right, I'm not going to do that. All right, Romello Exford Walker. Okay, so we're charged with aggravated assault, deadly weapon with intent to kill, and criminal mischief over $1,000. I do find probable cause. State, you want to be heard?
One moment, Your Honor. Does pretrial have any history? Your Honor, I'm going to be requesting a $7,500 bond based on the allegation that he intentionally attempted to strike the victim with his vehicle. And then it does mention that he was taken into custody during a high-risk traffic stop.
Judge, I'm sorry, Mr. Linder, I don't know if you're...
I'm done.
Okay. Judge, we're going to ask for the lowest reasonable bond. He's advised me he's not going to be able to afford what would amount to be $8,000 for him. He's from South Florida. He's lived here his whole life. He went away to go to college, but he's been back here. He's actually scheduled to leave on January 13th to go play basketball over in Tampa. He's working doing DoorDash delivery, so that's like $150, $200 a day. He lives with his mom. He's got 4 aunts. He's got his brother and sister. His mom is a principal, and so we'd ask for a lower bond than what the state is asking for.
All right, on count one, it's going to be a $5,000 bond. Count two is a $500 bond. No contact with both victims, Bianca Moses and Michelle Green. You understand that? That means you can't text, call, use social media or any other people to contact both of them. You understand?
Yes, ma'am.
Okay.
Okay.
All right, Jeffrey Vedrine.
It's Vedrine. He's here, Your Honor.
All right, sir, you're charged with carjacking with firearm or weapon. I do find probable cause.
Your Honor, the state would be seeking a finding of proof evident or presumption great, relying upon the arrest warrant and affidavit authored by Detective Tomlin of the Miramar Police Department. The state would be seeking a no bond hold, recognizing that the court's rulings would be applicable for first appearance purposes only.
And we would object to the court making such a finding at this point in time. Proof evident presumption great is the highest burden of proof that we have in the criminal justice system. The state has introduced no evidence, called no witnesses, and it is our opinion that they have fallen far short of that very high level of proof. So we would ask that the court set bond for Mr. Vadrine in this matter. If, over our objection, the court does make a finding that there is proof evident presumption great, then we would encourage the court to exercise its discretion and set bond for Mr. Vadrine.
Okay, I have reviewed this case, and I do find proof evident presumption great, and that is also pursuant to the 4th DCA case law on this matter, which I don't have memorized, and I left it in my
I
office.
believe Your Honor is referring to Isaza. That's the 4th DCA case.
Whichever was the most recent one.
That would be Isaza.
Okay. So, based on that, then there's no bond, correct?
That's for the.
Okay. All right. Stephen Leo?
Review?
He refused, Your Honor. We could resend him for tomorrow, I suppose.
What?
He refused.
Oh. Okay. He has a hearing tomorrow, so. Okay, 1 second. You can just, here.
Your Honor? Your Honor, I would inquire if the court would be inclined on Mr. Leo to have the clerk cancel that status, because frankly, the burglary is more serious than the county ordinance violation, and Judge Solomon can still resolve that county ordinance violation tomorrow if she so chooses. I just don't want to see the.
Sure.
I just don't want to see the felony get delayed.
That's, I would be asking to be appointed Mr. McLawrence's office. He handles the county ordinances, so if it's for sure gonna just be set for tomorrow, I would ask that we be appointed so that we can represent him there.
That's tomorrow. Jacare, I'm not denying, I'm reserving ruling until tomorrow. No, I'm reserving ruling till tomorrow. Jacare Delquin Rhodes.
Mr. Rhodes is present in the main jail.
All I'm saying is come back tomorrow. Yeah, thanks. All right, sir, you're charged with grand theft auto, burglary unoccupied, and 1, 2, 3.
Excuse me.
1, 2, 3, 4 violations of probation.
Your Honor, considering at least one of the offenses that Mr. Rhodes is on probation for is carjacking, and the nature of these charges, I'm requesting a $5,000 bond on count 2.
All right, I do find probable cause. You do have a hearing tomorrow at 8:30 on the probation violations. Sir, you want to be heard on count 1?
Well, I'm ready right now.
Why is it so loud?
Sure.
Is there any way to make it lower? Okay. You want to be heard?
Well, Judge, just Mr. Rhodes has lived here his whole life in South Florida. He lives in North Lauderdale with his mother-in-law and her kids. He's not working. He just got his GED in 2017.
Okay. I'm going to set the bond on count. I'm going to set the bond on count 1 at $2,500 and count 2 $2,500.
Thank you. Judge, can we call a case out of order?
Sure.
He's on page 18, top of page of 18, Wesley Demosteen. He's here in the main jail. Hi, Wesley.
Okay. Battery on an officer, firefighter, and trespass. I do find probable cause. This was reset, medical reset.
Yes, ma'am.
All right. So, what are we doing?
One moment, Your Honor.
Okay.
Your Honor, based on the,
Thank you.
Your Honor, based on the allegations and also the fact that he was adjudicated May 2nd of this year for shooting at or throwing a deadly missile, the state would be requesting a $2,500 bond.
Okay.
Judge, nothing to add at this time.
All right, so count one is 2,500. Do you want it on each count or no?
No, just on the bat
Okay.
lead.
All right. All right, next case is Blair George. No, I'm sorry.
Thank you,
George Blair.
Good morning.
Hi. You're charged with burglary, assault, or battery, so.
The state would be seeking a finding of proof evident or presumption great for first appearance purposes and a no bond hold. Mr. Blair was arrested in the victim's home. There are multiple witnesses whose stories corroborate one another that he forced his way into the home while armed with a machete and threatened to attack the alleged victim.
In light of the fact that Mr. Blair has a no bond hold on count 3, a violation of probation, we would be deferring any argument regarding proof evident presumption great until such time as Mr. Blair can appear before his division judge.
Okay, state, if they defer that, do I still have to make a ruling?
The defense can defer argument. This court still has to
I
make a
have to make
finding
a
one way or
finding,
the
that's
other.
what I thought.
But it just applies to this.
Okay, I read the probable cause affidavit, I do find proof evident, presumption great, and it's no bond hold, plus there's a BOP tomorrow at 8:30.
And Your Honor, while I understand that he's going to be held no bond, it does appear that at least some of these parties, that he knows at least some of these parties involved. So I
Sure.
would be requesting no victim contact while he remains in custody.
Okay, sir, you can't contact any of the victims, you understand that? No phone calls, no telling somebody else to contact them for you, you understand?
ma'am.
All right,
Understand?
okay. Donovan Henry.
Judge, he's coming up. He wants to know if his bond has already been posted on this case.
Not yet.
Okay.
All right, I do find probable cause, possession with intent to sell or deliver cannabis, possession of controlled substance, and drug paraphernalia use. State, do you want to be heard?
No, Judge. Bond's out.
All right. Do you want to be heard, defense?
Nothing from the defense,
All
Your
right,
Honor.
$1,000 bond on counts 1 and 2, 100 on count 1. I mean, count 3. That's right. All right. Peter Simone, burglary, occupied structure, unarmed, petty theft, grand
You
theft
refuse,
auto.
Judge.
Okay. Okay, Ronald Jeanette.
He also refused, Your Honor.
Your Honor, if I could be heard on Mr. Jeanette's case. Your Honor, he has been medically reset at least once, if not twice, and now is refusing today. I am asking the court, as the court is permitted pursuant to the rules of procedure, to first make a probable cause determination.
Okay, well,
Yeah, I don't really have an objection to that, Judge, but I'd ask you to set him over just to address issues of bond.
Well, there's a second.
can I go on?
I just asked if we could deal with one issue at a time.
All right,
Oh, okay.
let me,
All right.
this one I actually didn't read yet, it was the last one.
Four felonies and one misdemeanor.
Judge, if I might be heard on that, I don't see anything about an amount in the probable cause affidavit.
There's a different one. I was reading a different one. Okay.
Moment, Your Honor.
Yeah, it's on the, there's another page. It indicates that the total loss for the stolen items were $234.
Now, that would be a misdemeanor.
So that would be a misdemeanor.
One moment, Your Honor. That's the second PC.
Okay, so
there-
that's the one that is a misdemeanor.
Yes, exactly.
All right, so the first one,
And Your Honor, that's fine if the court wants, if the court is inclined based on Mr. Reedy's argument to find probable cause for theft on, petty theft on count one, the state has no objection to that.
I'll just allow you to perfect. on count
Well, Your Honor,
Too late?
well, no, it's
Can
not
we
that,
reset?
it's not that, Your Honor, it's, I frankly, I don't have an object, and I wouldn't ask for time, if the court is inclined to find probable cause for theft based on the allegations, since
There
it
is.
doesn't list an amount, I'm fine with, at this time, for
Okay.
PC for theft.
All right, PC for theft.
Okay. That being said, Your Honor, now that, well, unless, Mr. Reedy, any other objection from the defendant?
No.
Okay. That being said, Your Honor, I want to bring to the court's attention, and it has nothing to do with bond on these cases, but I think it is within the court's authority and jurisdiction. Mr. Janit has, in addition to this case, 4 pending felonies in Broward County and one pending misdemeanor. The misdemeanor, he was arrested literally 3 days before this offense, bonded out on the 21st and was arrested on the 23rd. All of these cases arise between October 19th and this arrest, December 23rd. It is within the court's discretion if you choose to esponte or revoke his bonds and release on those cases. I know he's not here. I don't think that now that the court has found probable cause, I don't think that prevents the court from making a finding. Just like, for instance, if pretrial believes that someone has violated pretrial, they are allowed to approach the judge without the defendant being present to have a warrant signed. I'm making this, I normally wouldn't make this request without him present, Your Honor, but frankly, Mr. Janit has shown there is no reason to have any confidence whatsoever that he will not continue to commit new law offenses while out of custody.
Okay, let me ask you, what was his first, what is he out on bond on?
He was arrested October, I'll just start from the first arrest,
And
Your
why
Honor.
didn't anybody revoke his bond?
Your Honor, if you want, I could inquire of the assigned ASAs.
Okay, that's okay.
Your Honor, first he was arrested October 19th of this year and posted bond the same day and was released for possession of cocaine, DWS third or subsequent offense, and drug paraphernalia.
Okay, so that's pending.
Yes, these are all pending.
Okay, that's one.
He was then arrested November 1st and was released December 7th. This was on a new case involving grand theft, possession of cocaine, possession of controlled substance without a prescription, DWLS. He was ROR'd ultimately on those charges. He posted also fleeing and eluding, reckless driving, and operating without a valid DL. He was arrested on a separate felony petty theft. He posted a $1,000 bond, and he also has
When was that date?
that arrest. I could check to see the
So
offense
they all
date.
occurred between November 1st and December 7th?
All of these occurred between October 19th and December 23rd.
And none of these, this bond didn't get revoked on any of these?
I'd have to go to Odyssey to see if motions were filed or not, Your Honor.
Oh, I see, they do.
But I can tell you, then he was
All right.
arrested.
Okay, go on.
Thank you, Judge.
There's more?
Yes, there is. He was then arrested December 12th for a grand theft and was released December 18th on a $1,000 bond. He was then arrested 2 days later, as I mentioned, December 20th, for a petty theft, posted a $25 bond, and was released the 21st, and then got arrested on these two offenses December 23rd, Your Honor. One moment. Yes.
Okay, I'm gonna revoke all those bonds.
And for the record, these are case numbers 19-13188, CF10A, 19-13530, CF10A, 19-14661, CF10A, 19-12469, MM10A, and 19-12706, CF10A. I will prepare
So that's
orders for the
5
court.
cases, and this is his 6th arrest.
Yes, ma'am.
All right.
I'll prepare orders.
Can I put no bond on the grand theft?
He's entitled to it. He has to. He is
entitled to a
constitutionally
bond?
entitled to a
Okay.
bond on these. It's the
Defense,
other.
do you want to be heard?
Well, Judge, now that count 1 is a misdemeanor, I'd ask for a
Oh,
$100
yeah.
bond on that. Other than that, it looks like Mr. Jeanette is going to be a guest of the county for some time.
I mean, while the standard bond for a petty theft is $100, I do believe all the other thefts he had pending is an aggravating factor enough to keep the bond at 1,000.
All right. Count 1 is 1,000, count 2 is 1,000. Well, I'm gonna make, is count 2 a felony?
Count 2 is a felony.
All right, I'm gonna make that 10,000. And I'm gonna make, and then.
You're on 3 and 4, Your Honor? Okay.
Actually, I'm gonna change count 2 to 25,000. Yep. Is that a wrap for now?
I think, yeah. Your Honor, if you want, I can have you sign them. It's going to
Sure.
take me a little while, so in the afternoon when we come back.
Okay.
Judge, we're coming back at 1 o'clock this afternoon?
It maybe like 1:15. Between
1:15?
figure around 1:15.
Okay.
All right.
Thank you, Judge.
Okay.
Judge, if